The courtroom fell silent as Anthony Wilson walked through the heavy wooden doors. He straightened his tie, a simple blue one he'd bought 5 years ago for his law school graduation. The small county courthouse was packed today, mostly with people waiting for their own cases to be called. Anthony took a deep breath and made his way to the front. Case number 47823, Wilson versus Brightline Development, the clerk announced in a bored voice. Anthony placed his worn leather briefcase on the table and pulled out his carefully organized notes. Across the aisle, 3 men in expensive suits whispered to each other. The Brightline legal team had arrived early, their table already covered with stacks of documents and 2 sleek laptops. Representing yourself today, Mr. Wilson? Judge Richard Blackwell peered down from the bench, his reading glasses perched at the tip of his nose. There was a hint of amusement in his voice, like he was watching a child attempting to ride a bike without training wheels. Yes, Your Honor, Anthony replied, his voice steady despite the fluttering in his stomach. The judge raised an eyebrow. Bold choice. Let's hope you've done your homework. A few chuckles rippled through the courtroom. The lead attorney for Brightline, a silver-haired man named Gregory Thompson, didn't bother hiding his smirk. Anthony had indeed done his homework. For the past 3 months, he'd spent every free moment preparing for this day. After working his day job as a school office administrator, he would head straight to the public library until closing time, researching similar cases and studying relevant laws. His small apartment had become a makeshift law office, with legal books borrowed from a former classmate and sticky notes covering every wall. Your Honor, if I may begin by addressing the motion to dismiss filed by the defense? Anthony asked. Judge Blackwell waved his hand dismissively. Go ahead, Mr. Wilson, let's see what you've got. Thank you, Your Honor. Anthony stood tall, ignoring the judge's tone. Brightline Development claims they had legal right to terminate our contract, based on Section 7.3, but their interpretation overlooks key provisions in both state law and the contract's own language. As Anthony began to outline his argument, Judge Blackwell interrupted. Mr. Wilson, I hope you realize that contract law isn't something you can just Google the night before. The judge turned toward the gallery with a knowing smile, clearly expecting laughter. Only a few nervous chuckles followed. Anthony noticed an older woman in the back row frowning at the judge's remark. I understand, Your Honor. Anthony replied calmly. I graduated from State University Law School 4 years ago. I'm familiar with contract law. The judge's eyebrows shot up in genuine surprise. Yet you couldn't find yourself a lawyer. Or perhaps, he paused, glancing at Anthony's modest suit. Couldn't afford one. The comment hung in the air. Anthony felt his face grow warm, but he kept his expression neutral. He'd faced worse during his time in law school, where he'd often been the only black student in his classes. I believe I can represent myself effectively in this matter. Your Honor, Anthony said, his voice betraying no emotion. Thompson, the Brightline attorney, cleared his throat. Your Honor, regardless of Mr. Wilson's qualifications, our motion to dismiss stands on solid legal ground. Mr. Wilson signed a contract with clear terms, and those terms were not met. Judge Blackwell nodded. Well said, Counselor. He turned back to Anthony. Your response, Mr. Wilson? Anthony opened his briefcase and pulled out a document. If the court would review Exhibit A, the original contract shows that Brightline added handwritten amendments after I signed the initial agreement. He passed copies to the clerk, who distributed them to the judge and opposing counsel. These amendments substantially altered the performance metrics without proper notification or consent. Under the Davis precedent from 2018, such alterations render those specific clauses unenforceable. The judge frowned as he reviewed the document. Davis precedent? Remind me. Anthony could see Thompson flipping through his notes, clearly caught off guard. Davis versus Westfield Construction, Your Honor. The state Supreme Court ruled that post-signing amendments require explicit consent from all parties, especially when they materially change performance requirements. Judge Blackwell's frown deepened. I'm familiar with the case, Mr. Wilson. I'm just surprised you are. His tone had shifted slightly. Additionally, Anthony continued, gaining confidence, Brightline's own emails, which I've submitted as Exhibit B, show they acknowledged receiving my deliverables on time according to the original agreement. Thompson jumped to his feet. Objection, Your Honor. Those emails were internal communications and not intended to serve as formal acknowledgments. That may be true, Anthony countered before the judge could speak. But the law doesn't distinguish between formal and informal acknowledgments when establishing a pattern of accepted practice. The Henderson ruling of 2019 made that quite clear. The courtroom had grown quieter now. People who had been half listening were now paying full attention. Judge Blackwell studied Anthony with a different expression, still skeptical, but with a hint of curiosity. "Let me see those emails," the judge said, holding out his hand. As the clerk delivered the documents, Anthony noticed Thompson whispering urgently to his colleagues. One of them was frantically typing on his laptop, probably searching for the Henderson case Anthony had mentioned. "Your Honor," Thompson said, rising again, "these emails were taken out of context. Our project manager was simply being polite, not officially accepting deliverables that failed to meet contractual standards. The emails specifically state, and I quote, deliverables received and reviewed." "Moving to next phase as discussed," Anthony replied. "That goes beyond politeness, Mr. Thompson." Judge Blackwell removed his glasses and rubbed the bridge of his nose. What had seemed like a simple case to dismiss was becoming more complicated. "Mr. Wilson," the judge said, his mocking tone now replaced with something more professional, "you mentioned the Henderson ruling. Please elaborate on how you believe it applies here." Anthony nodded, feeling a small surge of hope. At least the judge was listening now. In Henderson versus Tech Solutions, the court established that when a company's representatives consistently communicate in a manner that acknowledges compliance with contract terms, they cannot later claim non-compliance without clear evidence of deficiency notices issued at the time. One of Thompson's colleagues passed him a note. After reading it, Thompson's confident expression faltered slightly. "Your Honor," Thompson began, "while the Henderson case does exist, its circumstances were quite different from—" "Were they?" Anthony interrupted, pulling another document from his briefcase. Henderson was also a small contractor dealing with a large development firm. The communications pattern was nearly identical. The ruling specifically addresses power imbalances in contract enforcement. A murmur went through the courtroom. Judge Blackwell tapped his gavel once lightly. "I'd like both parties to approach the bench," the judge said. As Anthony walked forward, he felt the eyes of everyone in the courtroom on him. Just this morning he had stood in his small bathroom staring at his reflection, fighting the voice in his head that told him this was pointless. 4 years after graduating near the top of his class, he was still fighting for recognition in a profession that seemed determined to keep him on the outside. At the bench, Judge Blackwell lowered his voice. "Mr. Wilson, I'll be frank. I underestimated you, and that was inappropriate on my part." Anthony nodded but said nothing. "However," the judge continued, "this case is more complex than it initially appeared. I'm not granting the motion to dismiss today. Instead, I'm ordering both parties to submit additional briefs addressing the Henderson precedent and its applicability here." Thompson started to protest, but the judge held up his hand. "We'll reconvene in 2 weeks, Mr. Wilson. I expect your brief to be as well prepared as your argument today." "Yes, Your Honor. Thank you." As they stepped back from the bench, Anthony caught Thompson giving him a calculating look, the kind that said he wouldn't be underestimated again. When Anthony returned to his table, his hands were shaking slightly, but not from fear. For the first time in a long while, he felt the rush that had driven him to become a lawyer in the first place, the feeling of standing up for what was right and being heard. As the judge called the next case, Anthony packed up his materials. A young black law clerk who had been watching the proceedings gave him a subtle nod of respect as he passed by. Outside the courtroom, Anthony took a moment to sit on a bench in the hallway. He pulled out his phone to call his mother, who had always believed in him even when the rest of the world hadn't. He had just scored a small victory, but the real battle was still ahead. He would need to prepare even more thoroughly for the next hearing, but for now, just for this moment, he allowed himself to feel a quiet pride. Judge Blackwell had walked into that courtroom expecting to dismiss both his case and him. Now the judge would be spending the next 2 weeks thinking about Anthony Wilson and the legal argument that couldn't be so easily dismissed. Anthony's small apartment felt even smaller with legal books and papers spread across every surface. The kitchen table had disappeared under stacks of case law printouts. His living room couch was barely visible beneath folders of evidence and legal pads filled with notes. Even his bathroom counter held a legal dictionary he'd been reading while brushing his teeth. 2 days had passed since the hearing, and Anthony hadn't stopped working. The judge's order to submit additional briefs gave him a fighting chance, but he knew Brightline's team of attorneys would be working overtime to counter his arguments. His phone buzzed. It was his mother calling. "Hey, Mom," he answered, his voice tired but warm. "How's my lawyer doing today?" Her voice was filled with pride, the same way it had been when he'd graduated from law school 4 years ago. Anthony glanced at the clock. It was almost midnight. "Still working. This brief needs to be perfect. You eating proper? Taking breaks?" He looked at the empty coffee mug and half-eaten sandwich on the edge of his desk. "I'm managing." "That means no," his mother said with a knowing sigh. "Remember what your father always said. A tired mind makes mistakes," Anthony finished, smiling despite his exhaustion. His father had passed away during his second year of law school, but his wisdom remained a constant presence in Anthony's life. "He'd be so proud of you, standing up to that judge and those fancy lawyers." Anthony's smile faded. "I haven't won yet, Mom. But you didn't back down. That's a victory all its own." After they hung up, Anthony returned to his research. The Henderson case was good, but he needed more. Judge Blackwell might have been surprised by his knowledge, but the next time they met, the judge would be prepared. And so would Brightline's attorneys. The next morning, Anthony called in sick to his job at the school office. He couldn't afford to miss a day's pay, but he couldn't afford to lose this case either. He made his way to the county law library, a place he'd become very familiar with over the past months. Ms. Patterson, the head librarian, greeted him with a nod. "Back again, Mr. Wilson?" "Need to dig deeper on contract law precedents," Anthony replied, setting his briefcase down at his usual table by the window. "Heard about your hearing with Judge Blackwell," she said, lowering her voice. "News travels fast around the courthouse." Anthony looked up, surprised. "What are people saying?" Ms. Patterson smiled, the wrinkles around her eyes deepening. "That someone finally stood up to him. That man's been talking down to folks for years." She disappeared between the stacks, returning moments later with a heavy book. "You might find this useful. It's a compilation of recent state Supreme Court rulings on contract disputes." "Thank you," Anthony said, genuinely touched by her help. "Just doing my job," she replied, but her smile said otherwise. Anthony spent the entire day in the library, digging through case after case. By late afternoon, his eyes were burning from reading small print, but he'd found something promising: the Raymond case. It was more recent than Henderson and involved similar contract amendments. As he was making notes, a shadow fell across his table. Anthony looked up to see a man in an expensive suit standing there. He recognized him as one of Thompson's junior associates from Brightline's legal team. "Mr. Wilson," the man said, his voice carefully neutral. "Quite a performance yesterday." Anthony closed his notebook. "Just representing my client, myself." The associate glanced at the book spread across the table. "Mr. Thompson sent me to deliver a message. Brightline is willing to settle. $10,000 if you drop the case and sign an NDA. Anthony's heart raced. $10,000 would help with his student loans and the mounting bills on his kitchen counter, but the contract dispute was worth nearly 5 times that amount. That's significantly less than what was originally agreed upon in our contract, Anthony replied calmly. The associate shrugged. It's a guaranteed payment with no further legal fees or time investment. Mr. Thompson thought you might appreciate a practical solution. Anthony understood the subtext. They were hoping he would take the money because they thought he needed it. They were also hoping to avoid the possibility of losing in court. Please tell Mr. Thompson I appreciate the offer, but I'll be continuing with the case. The associate's professional smile faltered slightly. Are you sure that's wise? Our firm has resources you can't match. The outcome yesterday was unusual. So was Brightline changing the contract after I signed it, Anthony replied. Please let Mr. Thompson know my decision is final. After the associate left, Anthony sat back in his chair, his mind racing. Brightline was worried. Their settlement offer confirmed it, but it also meant they would come back even stronger at the next hearing. That night, Anthony barely slept. When he did, he dreamed of standing in front of Judge Blackwell, his mind going blank, unable to remember a single case or legal argument. He woke up at 4 a.m. covered in sweat. Instead of trying to go back to sleep, he made coffee and returned to his notes. If Brightline was worried enough to offer a settlement, he must be on the right track. He needed to press that advantage. The days blurred together as Anthony split his time between his day job and preparing his brief. He took lunch breaks in his car, reviewing notes while eating sandwiches. He stayed up late into the night, researching similar cases and refining his arguments. Twice he fell asleep at his desk, waking up with paper stuck to his cheek and a stiff neck. A week before the follow-up hearing, Anthony ran into an unexpected problem. His printer broke down while he was preparing copies of his brief. The repair would cost more than buying a new printer, but he couldn't afford either option right now. In desperation, he called his old law school classmate Dominic, who had been letting him borrow books. "Hey, man, I hate to ask, but could I use your office printer? Mine just died and I need to make copies for court." "No problem," Dominic replied. "When do you need it?" "As soon as possible. The hearing's next week. Come by the firm tomorrow morning. I'll let security know you're coming." The next day, Anthony found himself in the gleaming offices of Reynolds and Baker, where Dominic worked as an associate. The contrast with his own situation wasn't lost on him. While his classmate had landed at a prestigious firm right after graduation, Anthony had sent out hundreds of applications, only to face rejection after rejection. Eventually, he'd taken the school administrative job to pay the bills while continuing to apply to law firms. As Dominic showed him to the printer room, they passed a conference room where several attorneys were gathered around a table covered with documents. "Big case?" Anthony asked. Dominic nodded. "Contract dispute with a tech company. The partners have been working on it for weeks." Through the glass wall, Anthony could see the firm's senior partner gesturing at a document. Something about the scene made Anthony pause. He could just make out the heading on one of the projected slides: Contractual Amendments, Enforceability Standards. "Dom," Anthony said slowly, "that case they're working on, it wouldn't happen to involve post-signing amendments, would it?" Dominic looked surprised. "Yeah, actually. How'd you know?" Anthony's mind raced. "Just a guess based on what I could see." "Listen, could I ask a huge favor? Could you find out what cases they're citing regarding amendment enforceability?" Dominic hesitated. "That's getting into confidential territory, man." "I'm not asking for client information or strategy," Anthony clarified. "Just the public case law they're referencing. It could help with my situation." After a moment, Dominic nodded. "Let me see what I can do. No promises." Anthony finished printing his brief, but his mind was elsewhere. If a top firm was working on a similar issue, there might be precedents or arguments he hadn't considered. 2 days later, Dominic called. "I can't tell you much, but check out the Thorntonverse next-gen case from 2020. That's all I can say." Anthony thanked him and immediately headed to the law library. The Thornton case wasn't one he'd come across before, probably because it had been decided in a different state. But as he read through the ruling, his excitement grew. The judge had established a 3-part test for determining whether post-signing amendments were enforceable. If he applied that test to his own case, Brightline's position would fall apart. The night before the hearing, Anthony rehearsed his arguments in front of his bathroom mirror, timing himself to make sure he could present everything clearly within the time he'd likely be allowed to speak. His reflection showed the toll the past weeks had taken: dark circles under his eyes, his face thinner than usual, but also a determination that hadn't been there before. As he finally lay down to sleep, Anthony thought about his father. "This one's for you, Dad," he whispered into the darkness. Tomorrow would be the real test. Judge Blackwell wouldn't underestimate him this time, and neither would Brightline's attorneys. But this time, Anthony had something he hadn't fully possessed at the first hearing: confidence in his own abilities. His phone alarm went off at 5:30 a.m. Anthony got up immediately, his mind already focused on the day ahead. He laid out his best suit, the one he had worn to his law school graduation, and prepared for battle. The courthouse seemed different this time. As Anthony walked through the security checkpoint, he noticed people nodding at him. The security guard, a clerk he'd seen before, even a couple of attorneys waiting by the elevator. Word had spread about the first hearing, and it felt like they were watching to see what would happen next. Anthony arrived early, wanting to settle his nerves and organize his materials one last time. The courtroom was still mostly empty. He chose the same table as before and methodically arranged his documents, the brief he'd submitted last week, supporting evidence and notes on the Thornton case he'd discovered through Dominic's tip. Across the aisle, Brightline's table remained empty. Anthony checked his watch. Still 30 minutes before the scheduled start time. The courtroom doors opened and Thompson walked in, followed by not 2 but 4 associates. Their table quickly became crowded with laptops, legal pads, and binders. Anthony tried not to let the sight intimidate him. They might have numbers, but he had put in the work. Thompson glanced over, giving Anthony a curt nod before turning to whisper instructions to his team. One of the associates handed Thompson a thick folder with colored tabs, their response to Anthony's brief. More people filtered into the courtroom. Anthony was surprised to see Ms. Patterson, the law librarian, slip into a seat in the back row. She caught his eye and gave him an encouraging smile. A few rows ahead of her sat a young black woman in a tailored suit, whom Anthony recognized as a clerk from another courtroom. Next to her was the older woman who had frowned at Judge Blackwell's remarks during the first hearing. At precisely 9:30 a.m., the bailiff called the court to order. Judge Blackwell entered, his robe swishing as he took his seat at the bench. His expression gave nothing away as he surveyed the room. Case number 47823, Wilson versus Brightline Development, the clerk announced. Judge Blackwell adjusted his glasses. I've reviewed the brief submitted by both parties. I must say this case has become more interesting than I initially anticipated. His eyes moved between Anthony and Thompson. Mr. Wilson, since you prevailed against the motion to dismiss, would you like to begin? Anthony stood, taking a deep breath to steady himself. Thank you, Your Honor. I'd like to address 3 key points today: the enforceability of post-signing amendments, the established pattern of acceptance of deliverables, and the application of the Thornton 3-part test to the facts of this case. Judge Blackwell's eyebrows rose slightly at the mention of Thornton. Proceed. Anthony moved from behind the table, standing confidently before the bench. As established in my brief, Brightline Development added performance metrics to our contract after I had signed the original agreement. While they claim these amendments were clarifications, the evidence shows they substantially altered the terms. He picked up a document from his table. Exhibit C, which was not available during our last hearing, shows the original performance metrics compared to the amended version. The changes increased delivery requirements by 40% while keeping the payment schedule unchanged. Thompson shifted in his seat. This was new evidence Anthony had uncovered during his intensive research over the past 2 weeks. Under the Davis precedent we discussed previously, such changes require explicit consent. But I'd like to take this further by applying the Thornton 3-part test established in 2020. Judge Blackwell leaned forward. The Thornton case? That's from the 6th Circuit, Mr. Wilson, not binding precedent in our jurisdiction. Anthony nodded, prepared for this objection. That's correct, Your Honor. However, 3 state courts have since adopted its reasoning, including Judge Rivera in the Lewis case just last month. He pulled another document from his folder. I've included the relevant citations in my supplemental brief. Thompson stood abruptly. Your Honor, the Lewis case was only decided 4 weeks ago. It wasn't included in Mr. Wilson's initial brief. It was included in my supplemental materials filed 3 days ago, well within the timeline established by the court. Anthony replied calmly. The clerk's office has confirmed receipt. Judge Blackwell flipped through the papers before him. He's right, Mr. Thompson. The supplemental brief was properly filed. The judge turned back to Anthony. Continue with your argument regarding the Thornton test. Anthony felt a small surge of confidence. Thank you, Your Honor. The Thornton test establishes 3 criteria for post-signing amendments to be enforceable. First, both parties must have clear notice. Second, the amendments must not fundamentally alter the nature of the agreement. And third, there must be some form of consideration for the additional obligations. Anthony walked to the projector that had been set up at his request. With the court's permission, I'd like to show how Brightline's amendments fail all 3 parts of this test. Judge Blackwell nodded, his expression now one of genuine interest rather than the dismissive amusement he'd shown at their first meeting. For the next 20 minutes, Anthony methodically laid out his case, showing side-by-side comparisons of the original contract and the amended version. He highlighted specific emails where Brightline's project managers had acknowledged receiving his deliverables without raising any concerns about quality or timeliness. His presentation was clear, focused, and, most importantly, persuasive. In conclusion, Your Honor, Brightline terminated our contract claiming I had failed to meet performance standards that were improperly added after the fact. Under both the Davis precedent and the Thornton test, these amendments cannot be enforced against me. I respectfully ask the court to find that Brightline breached our contract when they terminated it, and to award the damages outlined in my brief. Anthony returned to his seat, aware of the silence in the courtroom. He had done everything he could to prepare for this moment. Now it was Thompson's turn. The Brightline attorney approached the podium with the confidence of someone who had done this hundreds of times before. Your Honor, while Mr. Wilson has certainly done his homework, his arguments rest on a fundamental misunderstanding of contract law. Thompson began his counter-argument, suggesting that Anthony had actually consented to the amendments through his continued work on the project. He cited several cases supporting the concept of implied consent, though Anthony noticed they were all from before the Davis ruling. As Thompson spoke, Judge Blackwell interrupted several times with pointed questions. This was different from the first hearing, where the judge had seemed ready to side with Brightline from the start. Mr. Thompson, the judge said after one particularly weak argument, are you suggesting that a party with superior bargaining power can unilaterally alter contract terms as long as the other party continues performance? Thompson hesitated. Not unilaterally, Your Honor, but when a contractor continues to work under revised specifications without formal objection. But Mr. Wilson has presented emails showing he did question the changes. Judge Blackwell interrupted, flipping through the exhibits. According to Exhibit D, he wrote, and I quote, "These new requirements appear to substantially increase the scope of work without corresponding compensation adjustments. Please clarify if these are suggestions or requirements." Thompson cleared his throat. Yes, Your Honor, but Brightline responded that these were clarifications of existing requirements, not new ones. Calling something a clarification doesn't make it so, the judge replied dryly. The actual content of the changes is what matters legally. Anthony tried to keep his expression neutral, but inside, his heart was racing. Judge Blackwell was actually engaging with his arguments and challenging Thompson's position. When Thompson finished his presentation, the judge called for a brief recess before rebuttals. Anthony remained at his table, reviewing his notes for any points he needed to address. From the corner of his eye, he saw several people approach Thompson, speaking in hushed, urgent tones. Ms. Patterson walked by Anthony's table on her way out. "You're doing well," she whispered. "Keep it up." When court resumed 15 minutes later, Anthony delivered a concise rebuttal, addressing each of Thompson's main points and returning repeatedly to the Thornton test. He finished by displaying one final slide, an email from Brightline's CEO to the project manager that Anthony had obtained through discovery. In this email, dated 2 weeks before my termination, the CEO writes, "The new metrics aren't being met. Find a way to break the contract so we can bring in someone cheaper for Phase 2. This demonstrates that Brightline's true motivation was not my performance, but their desire to cut costs after securing initial deliverables." A murmur ran through the courtroom. Thompson's face had gone pale. This email had been buried in thousands of documents produced during discovery, but Anthony had found it during his sleepless nights of preparation. Judge Blackwell removed his glasses, his expression serious. "That's a damning piece of evidence, Mr. Wilson." Thompson jumped to his feet. "Your Honor, that email lacks context." The CEO was merely exploring options. "The language seems quite clear to me," the judge interrupted. "Unless you have an alternate interpretation that somehow transforms, find a way to break the contract into something benign." Thompson had no good answer. After both sides completed their arguments, Judge Blackwell surprised everyone by announcing he would issue his ruling immediately, rather than taking it under advisement. Based on the evidence and arguments presented, I find that Brightline Development improperly attempted to modify the contract after execution without proper consent or consideration. The termination of Mr. Wilson's contract was therefore a breach. Anthony felt a wave of relief wash over him, but the judge wasn't finished. Furthermore, the email evidence suggesting Brightline's bad faith in this matter is particularly troubling. I am therefore awarding Mr. Wilson the full contract amount of $47,500 plus reasonable attorney's fees. Judge Blackwell paused, a small smile forming at the corner of his mouth. Though in this case, Mr. Wilson has saved himself considerable expense by providing his own excellent representation. The courtroom erupted in muffled conversations. Thompson sat stunned while his associates frantically whispered among themselves. Anthony remained still, almost unable to believe what had just happened. "Court is adjourned," Judge Blackwell announced, bringing down his gavel. As people began to file out, Judge Blackwell caught Anthony's eye. "Mr. Wilson, a word in my chambers, if you don't mind." Anthony nodded, gathering his materials. Whatever the judge wanted to say, Anthony had already achieved what many had thought impossible. He had stood his ground, trusted his abilities, and won. Anthony followed the bailiff down a narrow hallway behind the courtroom. His heart was still racing from the victory, but now a new nervousness took hold. What did Judge Blackwell want to discuss in private? The judge's chambers were exactly what Anthony had imagined. Wood-paneled walls lined with law books, certificates, and a few personal photos. A large desk dominated the room with 2 leather chairs positioned in front. Judge Blackwell was already seated behind the desk, his black robe draped over a coat rack in the corner. Without the robe, in just his shirt and tie, he looked more human somehow. "Please sit down, Mr. Wilson," the judge said. Gesturing to one of the chairs, Anthony sat, placing his briefcase on the floor beside him. The leather chair creaked under his weight. "I owe you an apology," Judge Blackwell said, getting straight to the point. Anthony blinked in surprise. "Your Honor? At our first hearing, I made assumptions about you. Unfair assumptions." The judge leaned forward, his hands clasped on the desk. "I've been on the bench for 17 years, and I like to think I can size up a case and the people involved pretty quickly. But I was wrong about you." Anthony wasn't sure how to respond. He hadn't expected this level of candor. "Thank you for acknowledging that, Your Honor." Judge Blackwell nodded. "Where did you go to law school again?" "State University Law. Graduated 4 years ago." "Near the top of your class, I'm guessing?" Anthony nodded. "Third." The judge's eyebrows rose. "And yet you're working as a school administrator instead of at a firm?" It wasn't really a question, more an observation tinged with genuine curiosity. Anthony shifted in his seat. He had been asked some version of this question many times over the past 4 years. Usually he gave a vague answer about waiting for the right opportunity. But something about this moment, perhaps the victory still buzzing in his veins, made him decide to be honest. "I've applied to 67 law firms since graduation." "Your Honor, I've had 14 interviews. No offers," Judge Blackwell frowned. "With your abilities? That's surprising, is it?" Anthony asked quietly. The question hung in the air between them. Judge Blackwell's gaze dropped to his desk for a moment, then back to Anthony. "No," he finally admitted. "It shouldn't be surprising. But it should be unacceptable." The judge stood up and walked to the window overlooking the courthouse square below. "You know, when I first started practicing law 30 years ago, I thought things were changing. Slowly, yes, but changing. Now I'm not so sure." He turned back to Anthony. "But that's not why I asked you here. I asked you here because I was impressed by your work today. Not just your legal research, which was excellent, but your presentation, your ability to break down complex legal principles for the court. Not many attorneys, even experienced ones, can do that effectively. Thank you, Your Honor. I'm curious, what are your plans now? Will you continue at the school?" Anthony hadn't thought beyond winning the case. For so long, his focus had been on preparing for this battle. "I'm not sure. The settlement will help, but it won't last forever." Judge Blackwell returned to his desk and pulled out a business card from a drawer. "I'd like you to call this person. His name is Lawrence Washington. He's the managing partner at Washington, Chen & Associates. They're a mid-sized firm specializing in contract and business law." Anthony took the card, confused. "I don't understand. Lawrence is an old friend of mine. We went to law school together. His firm is looking for new associates with trial experience." Judge Blackwell gave a small smile. "I'd say you qualify now. You're recommending me for a job?" Anthony couldn't keep the surprise from his voice. "I'm recommending that Lawrence would be a fool not to at least interview you. What happens after that is between you and him." The judge leaned back in his chair. "The legal profession needs people like you, Mr. Wilson. People who will put in the work, who understand the law isn't just about who has the most expensive suit or the fanciest degree. Anthony looked down at the card in his hand. Washington, Chen and Associates. He had actually applied there 2 years ago and never heard back. I appreciate this, Your Honor, truly. Don't thank me yet. Lawrence can be a tough interviewer. Judge Blackwell's expression became more serious. There's something else I wanted to discuss with you. Yes? That email you found? The one from Brightline's CEO? The judge shook his head. That was the kind of smoking gun most attorneys dream about finding. How did you uncover it? Anthony thought back to the long nights poring over thousands of documents. Honestly, just hard work and persistence. They produced over 5,000 emails in discovery. I read every single one. Judge Blackwell looked impressed. Most firms would have assigned that to a team of paralegals or junior associates. You did it alone. I didn't have much choice, Anthony said with a slight smile. Well, your thoroughness paid off. That email shifted this from a simple contract dispute to clear evidence of bad faith dealing. Which brings me to my next point. The judge pulled a file folder from his desk. Have you considered filing a complaint with the State Contract Review Board? Anthony frowned. I haven't. What would that involve? Brightline does government work, schools, municipal buildings. The review board oversees contractors who receive public funds. Evidence of deliberate contract breaking could potentially bar them from government projects for several years. Anthony hadn't thought beyond his own case, but the idea made sense. If Brightline had done this to him, they might have done it to others. I'll look into it, Anthony promised. Judge Blackwell nodded, seemingly satisfied. Good. Now I've taken enough of your time. He stood up, extending his hand. Congratulations on your victory today, Mr. Wilson. It was well earned. Anthony rose and shook the judge's hand firmly. Thank you, Your Honor. As Anthony turned to leave, the judge added, and Mr. Wilson, when you do join a firm, because I have no doubt you will, I hope you'll remember what it felt like to be on the other side. Not everyone can afford high-priced legal representation. Anthony nodded. I won't forget. Outside the courthouse, Anthony stood on the steps, blinking in the bright sunlight. The reality of what had just happened was still sinking in. He had won, not just the case, but potentially a shot at the career he'd been working toward for years. He pulled out his phone to call his mother, but paused when he saw Miss Patterson walking down the steps. Mr. Wilson, she called out, I wanted to congratulate you before I headed back to the library. Thank you for coming today, Anthony said. And for all your help with the research, the librarian smiled. That's what libraries are for. But I have to say, in 23 years working at the law library, I've rarely seen someone put in the kind of hours you did. She patted his arm. It paid off. After Miss Patterson left, Anthony was about to call his mother when another figure approached him, the young black woman he'd noticed in the courtroom. Excuse me, she said. My name is Vanessa Taylor. I'm a clerk for Judge Henderson in courtroom 3. Nice to meet you, Anthony replied, wondering why she was approaching him. I just wanted to say that what you did in there was remarkable. Her eyes were bright with admiration. I'm in my second year of law school night program, working as a clerk during the day. Anthony remembered how that felt. The exhaustion of balancing work and school, the determination to make it through. That's a tough road, he said, but worth it. I hope so. Vanessa hesitated. Would you be willing to get coffee sometime? I'd love to hear more about how you prepared for today's hearing. The way you presented those cases was so clear. Anthony was touched by her request. 4 years ago, when he'd graduated, he had hoped to be a mentor to younger law students someday. That opportunity had never materialized, until now. I'd be happy to, he said, taking out his phone. Let's exchange numbers. After they exchanged contact information, Vanessa headed back into the courthouse for the afternoon session. Anthony finally had a moment alone to call his mother. Mom, it's me, he said when she answered. We won, all of it. Her joyful cry was so loud he had to hold the phone away from his ear. I knew you could do it. Your father is looking down right now, so proud he could burst. Anthony smiled, feeling a weight lifting from his shoulders. There's more. The judge recommended me to a law firm. A real one, Mom, for an interview. Oh, baby, she said, her voice breaking. It's all happening for you finally. As Anthony walked to his car, he realized she was right. Things were finally happening. But more than that, he had proven something to himself. Despite the obstacles, despite the doubts, both external and internal, he had shown what he was capable of. The business card from Judge Blackwell felt like a promise in his pocket. Tomorrow he would call Lawrence Washington. Tomorrow he would start the next chapter of his journey. But today he would celebrate. He had faced a system that had repeatedly told him he didn't belong, and he had won not just through determination, but through excellence. No one could take that away from him. As he drove away from the courthouse, Anthony glanced in his rearview mirror at the imposing building receding behind him. He had entered those doors 2 weeks ago feeling like an outsider. He left today feeling like a lawyer. A real lawyer, and no one could ever make him feel otherwise again. 6 months later, Anthony stood in front of his bathroom mirror adjusting his tie. Not the old blue one from law school, but a new burgundy one that his mother had given him as a gift. For new beginnings, she had said. Today marked his first major court appearance as an associate attorney at Washington Chen & Associates. The face staring back at him in the mirror looked different somehow. More confident, more assured. The dark circles under his eyes were gone, replaced by a well-rested alertness. His phone buzzed on the counter. A text from Lawrence Washington. Big day. You ready? Anthony smiled and typed back, Born ready. The journey to this moment had been far from smooth. His interview with Lawrence Washington had been intense. 4 hours of legal hypotheticals, ethical scenarios, and probing questions about his background. Lawrence hadn't offered him the job on the spot. Instead, he had asked Anthony to complete a writing assignment analyzing a complex contract dispute. Anthony had spent 3 days on that assignment, applying everything he had learned from his own case. When he finally submitted it, he felt confident he had done his best work. 2 days later, Lawrence called with a job offer. The salary was lower than what top firms paid, but it was 3 times what Anthony had been making at the school. More importantly, it was a real chance to practice law. Anthony's first weeks at the firm had been a whirlwind of learning new systems, meeting colleagues, and adjusting to the rhythm of legal practice. Some attorneys had been welcoming. Others kept their distance, watching him with curious or skeptical eyes. Anthony didn't mind. He was used to proving himself. Lawrence had assigned him to a mix of cases, some simple contract reviews, a few negotiations, and today's court appearance. It was a relatively straightforward motion hearing, but Anthony had prepared as thoroughly as he had for his own case against Brightline. After one final adjustment to his tie, Anthony grabbed his briefcase and headed out. His new apartment was closer to downtown, a modest 1-bedroom that felt like a palace compared to his old place. The settlement money from Brightline had covered the security deposit and first month's rent, with enough left over to pay down some of his student loans. Anthony's phone buzzed again as he walked to his car. This time it was Vanessa, the law clerk he'd met outside the courthouse. Good luck today. You're going to crush it. Their coffee chat had turned into regular study sessions. Anthony was helping Vanessa prepare for her final year of law school, sharing insights from his own experience and now from his work at the firm. He found that teaching helped him clarify his own understanding of legal concepts. The courthouse looked different now that he approached it as an attorney rather than a pro se litigant. He nodded to the security guards, who recognized him and waved him through. In the main hallway, he spotted a familiar face, Judge Blackwell, walking between courtrooms with a stack of files under his arm. The judge noticed him too. Mr. Wilson, good morning. Good morning, Your Honor. I hear you're with Washington now. Lawrence says you're doing excellent work. Anthony was surprised. He told you that? Judge Blackwell smiled slightly. We have lunch once a month. Your name may have come up. He glanced at his watch. I should get going. Good luck with whatever brings you here today. Thank you, Your Honor. As the judge walked away, Anthony felt a sense of satisfaction. He had earned his place here. Courtroom 5 was already busy when Anthony entered. He spotted his client, a small business owner named Robert Chen, no relation to the firm's partner, sitting nervously in the front row. Anthony gave him a reassuring nod before setting up at the plaintiff's table. The case was straightforward, but important to Robert. His food supply company had delivered $30,000 worth of specialty ingredients to a restaurant that had since refused to pay, claiming the goods were substandard. Anthony had gathered evidence proving the ingredients met all specified requirements. The defense attorney, Philip Benson, was already at his table. Anthony had researched him thoroughly. 20 years of experience, aggressive reputation, known for trying to intimidate newer attorneys. First time in Judge Patel's courtroom? Benson asked with a thin smile as Anthony organized his materials. Yes, Anthony replied simply, not taking the bait. She likes things done her way. Very particular. Might be a tough day for you. Benson's tone was casual, but the message was clear. He was trying to shake Anthony's confidence. Anthony just nodded politely. Thanks for the heads up. 5 minutes later, Judge Patel entered. She was a small woman with sharp eyes that seemed to take in everything at once. Good morning, counselors. I've reviewed the motions. Mr. Benson, you're up first. Benson approached the podium with the swagger of someone who had done this thousands of times. His argument was well crafted, focusing on supposed deficiencies in the ingredients and attacking the testing methodology Anthony's client had used to verify quality. Anthony listened carefully, making notes of points to address. When it was his turn, he approached the podium calmly, just as he had in his own case months ago. Your Honor, while Mr. Benson has presented an elaborate argument, this case ultimately hinges on 3 simple facts. Anthony proceeded to break down the contract terms, the delivery specifications, and the independent verification of ingredient quality. He had anticipated Benson's arguments and methodically dismantled each one, citing relevant case law and presenting documentary evidence in a clear, accessible way. Judge Patel interrupted several times with probing questions. Each time, Anthony responded directly and concisely, never getting flustered or defensive. When Anthony returned to his seat, he could feel Benson staring at him. The older attorney seemed surprised by the thoroughness of Anthony's presentation. After brief rebuttals, Judge Patel rendered her decision immediately. Based on the evidence presented, I'm denying the defendant's motion to dismiss. Furthermore, I'm granting the plaintiff's motion for summary judgment on the issue of contract compliance. The ingredients clearly met the specifications in the contract. The only remaining issue for trial is the exact amount owed, including any applicable interest and penalties. Anthony's client, Robert, grabbed his arm in excitement. That's good, right? He whispered. Very good, Anthony confirmed. She just ruled that they can't claim the ingredients were defective. Now it's just about getting you paid. As they packed up to leave, Benson approached them. Nice work in there, he said to Anthony, his tone more respectful than before. Lawrence found himself a good one. Thank you, Anthony replied, shaking the offered hand. Outside the courtroom, Robert couldn't contain his excitement. You were amazing. The way you broke everything down so clearly. Even I understood all the legal stuff. Anthony smiled. That's the goal. The law shouldn't be mysterious. After scheduling a follow-up meeting with Robert for later that week, Anthony headed to his office to report the good news to Lawrence. As he walked through the firm's glass doors, he noticed several associates gathered around the reception desk, looking at something. What's going on? He asked Lisa, one of the paralegals he had befriended. The State Contract Review Board just published their quarterly enforcement actions, she explained. Brightline Development got barred from government contracts for 3 years. Lawrence is ecstatic because we represent one of their competitors. Anthony tried to keep his expression neutral, but inside he felt a surge of satisfaction. His complaint to the review board, filed shortly after his case concluded, had made a difference. That's quite a penalty, he remarked. Apparently someone provided evidence that they were deliberately breaking contracts to increase profits. Lisa continued. The board's report called it a pattern of bad faith dealings unacceptable in public contracting. Anthony nodded and continued to his office, a small but bright space with a window overlooking the city. On his desk was a framed photo of him with his mother at his law school graduation, and beside it a newer one, Anthony being sworn into the State Bar Association, with Lawrence Washington and his mother standing proudly beside him. He set down his briefcase and called his mother to share the news about the hearing. As always, she was his biggest cheerleader, telling him how proud his father would be. After they hung up, Anthony leaned back in his chair and looked out at the city spread below him. 6 months ago, he had been working at a school, his law degree seemingly wasted, Now he was doing what he had always dreamed of, practicing law, making a difference, and opening doors for others like himself. There was a knock at his door. Lawrence Washington stood there, his imposing figure filling the doorframe. "Heard about your win today? Judge Patel doesn't give out summary judgments easily." "It was a solid case," Anthony replied modestly. Lawrence entered the office and closed the door behind him. "I have a proposition for you. The firm is starting a pro bono program for entrepreneurs from underserved communities, small business owners who need legal help but can't afford typical firm rates. I want you to help lead it." Anthony was surprised. "Me? I've only been here 6 months. Who better? You understand what it's like to fight against the odds." Lawrence handed him a folder. "Look it over. We'll talk more tomorrow." After Lawrence left, Anthony opened the folder and began reading the program outline. It was exactly the kind of work he had hoped to do someday, using his legal skills to help others who faced the same barriers he had encountered. His phone buzzed with a text from Vanessa. "How did it go?" Anthony smiled and replied, "1, and it's just the beginning." He turned back to the window, watching as the afternoon sun glinted off the buildings downtown. Anthony Wilson, attorney at law. He had earned that title, not just through his degree, but through persistence, excellence, and the courage to stand up for himself when no one else would. The journey ahead would have its own challenges, but Anthony was ready for them. He had proven to Judge Blackwell, to Brightline, and most importantly to himself, that he belonged. And now he was going to help others find their place too. That was the true victory. Not just winning a case, but changing the system from within, one client, one courtroom, one pro bono program at a time. The work was just beginning, and Anthony couldn't wait to get started.